The topic that has been given to me, or rather a very interesting topic, is titled as Stages of a Civil Suit. And that is the topic for the webinar today. What I will aim to do is actually take each one of you through a journey of what basically takes place when a civil wrong occurs, or some sort of injury or harm is caused to somebody, mental, physical, which results in civil consequences. So, what is the journey of a person who faces such a civil wrong, and how he must remedy this wrong? So, that is basically the motive of today's lecture. As far as understanding what a civil suit is, firstly, the first thing that occurs to everybody would generally be what we call as CPC, or the Code of Civil Procedure, Civil Procedure Code 1908. It's one of the oldest statutes in our country, and it's a pre-independence legislation. And interestingly, it is in operation for over 114 years, because it came into effect from 1909 and we are in 2022. But the basic frame of the legislation continues till date. So the legislators at that point of time, whoever had enacted this procedure for determining civil procedure of our country, it was so strong-willed and so well thought of that it exists till date. So actually studying this law in depth is something which is not something easy and not something which someone can grasp, because it basically, this law has covered so many aspects and so many situations which basically which have been similar from 114 years, and that's why this law still is applicable to situations of today. So it's a law which was applicable to situations 114 years back, as well as which is applicable to situations today in 2022. That is the strength or the potency of the procedure established under the CPC, as we know. So before we begin that, or before we begin the journey of a civil suit, I'm sure most of you are lawyers or law students, and all of you have a basic background of law. But just to make sure that we all have revised, I thought of making a few concepts clear, or at least for me, understanding these concepts at least helped me understand what the CPC is. So first and foremost, before we begin the journey of a civil suit, what is of utmost importance is a basic introduction to a civil dispute, because one often gets confused, or rather it becomes a more vague or an undefinable term. What we say is a civil dispute. In fact, when we ask our fellow colleagues or lawyers, what law do you practice? So generally, if someone is exclusively practicing in the criminal field, they will say, I'm a criminal lawyer. But rarely do you see people say, I'm a civil lawyer, or even if they say that I'm a civil lawyer, the scope of their work is not very clear. Or rather, you still have to ask them, oh, what kind of civil law? And the answer is very simple. The why this happens is because what is a civil dispute is something which is so vast and so expansive that there cannot be one definition of what is a civil dispute. Or rather, to understand what a civil dispute is, we must firstly understand what a criminal dispute is. And therefore, what I would firstly place stress on is Section 9 of CPC. Section 9 of CPC is basically the enabling provision which vests jurisdiction in all civil courts. And it is so wide, okay, that what it basically holds, what Section 9 basically holds, is that a civil court has the jurisdiction to try all suits of a civil nature. Again, what is civil nature? Not defined. Anywhere in the CPC, not defined. Anywhere in any other law, not defined. So civil nature, civil dispute, civil wrong, not defined under law or under statute. So, but what Section 9 says is that civil courts will have jurisdiction to try all suits of a civil nature, excepting suits which are barred either expressly or impliedly. So, unless something is barred under law, and if it is of a civil nature, you can try that matter in a civil court, or rather, it is a civil dispute. So everything under the sun which falls under nature of a civil dispute and which is not barred under a law is tried by the civil court, or rather, whatever is, we can say in a way that whatever is not criminal is basically a civil dispute. So what becomes the difference between a civil and criminal dispute, or civil and criminal wrong, is something which might occur to somebody. So obviously, as we all know, a criminal wrong is a wrong which is against the society. Every wrong basically has two consequences. It has an impact on society as well as it has an impact on an individual. Let's say, for example, a case of fraud. Okay, when someone commits a fraud on somebody, that fraudulent act has an impact on society as a whole. Okay, and that defrauding of a person is a harm to the society as a whole, which has a criminal consequence, which we often know as cheating or criminal breach of trust or forgery. Fraud has its different aspects. But let's say, for example, cheating, 420 of IPC. So that is the criminal aspect of the act of fraud. However, when someone commits the act of fraud, there is also a civil consequence to this act. And that civil consequence obviously is that harm caused to the individual who has been defrauded, cheated, etc. So, what is the remedy for this person is not obviously approaching the criminal court, because he cannot. What the criminal court will do is just see whether this accused is punishable, whether this accused has committed an offense, whether the acts of the accused are punishable, and he will punish him. The wrong won't be remedied as far as the individual is concerned by punishment. To remedy this wrong is what the CPC provides for, or rather is what we have the civil law for. So therefore, the basic purpose of what the CPC is for, or what the entire civil law is for, is to provide a remedy to an individual when a civil wrong takes place. And that is why we have the CPC, because the CPC is basically based upon public policy. It is not a law intended to protect society as a large in effect. What it actually does is it establishes a procedure, okay, to be complied with, to ascertain the truth, to come to the real controversy, to ascertain the real controversy, to determine whether a civil wrong has taken place to somebody, whether a personal injury has taken place to somebody, and then therefore remedy that wrong by providing the procedure. And that is why when you try to understand the scope of CPC, this basic fundamental rule of why we have a CPC is very important. So therefore, to understand why we have the CPC, we must understand the clear-cut distinction between a civil and a criminal wrong. Because when it comes to criminal wrongs, there's a CRPC, completely different statute, which aims at protecting the society at a large. It aims at protecting the interests of society from crimes. What the CPC aims to do is to protect the individuals, rather to protect the interests of the individuals in a situation where a civil wrong takes place. We as law students also have learned something which is known as torts. Now, torts in India aren't recognized much differently than the way they are recognized under our civil law. Meaning, a tort is not a tort in India unless it is accompanied with a claim or a civil claim. So, to actually, when a tort actually takes place, a tortious activity takes place, the remedy for this person would be to file a civil suit, and the procedure established under CPC. And therefore, the basic rule for claiming damages, property, or any sort of recovery of money or movable and immovable property would be through the CPC. And that is the basic intention of the CPC. Now, if that is the case, then who hears these matters? And the answer is very clear. Those are the civil courts. The civil courts are basically trial courts having original jurisdiction. They are fact-finding forums which are established to ascertain the truth. And as long as a civil court is competent to hear the matter, that is, it has jurisdiction, which is of three kinds. One is territorial, pecuniary, and subject matter. So if these three jurisdictions are vested in the court, in the civil court, it can try any suit of any nature. Any civil claim of any nature can be tried as long as the civil court has territorial, pecuniary, and subject matter jurisdiction. I've also given in this slide, you can see that the territorial jurisdictions, the sections of 16 to 20, pecuniary section 4, as well as special state laws, which determine what will be the monetary value of the claim, until what monetary value can the claim be heard by that civil court, and subject matter jurisdiction, which, as I spoke on section 9, that unless the jurisdiction is expressly or impliedly barred. For example, if we take the family court, so up until 1984, the family court was not established in our country. So there was no family courts within a state or within every district. And therefore, if someone wanted to claim divorce or seek divorce, they would have to approach the civil court, or rather maybe the high court or the district court, depending on the jurisdiction. This subject matter of family laws was then thereafter excluded and taken away from the civil courts and given to a special court, that is the family court. So to understand when CPC will apply, or rather when a suit is a civil suit, one must always remember that it can only be a civil suit if it is presented before a civil court having territorial, pecuniary, and subject matter jurisdiction. Once this threefold test is complied with, then we begin with the civil suit. So to understand what is a civil suit, we must understand firstly what is a civil dispute, and secondly, what are the civil courts. Once this is clear, then we begin to understand how the civil suit will go ahead, or rather, how the journey of the civil suit will begin. Similarly, what one must also understand is the hierarchy of civil courts, because this becomes of utmost importance when we're trying to understand the hierarchy of civil courts. So it is obviously like the pyramid structure of our judicial nation, and the hierarchy of civil courts is as under. So firstly, at the apex will be the Supreme Court. Or I begin from the bottom. So when we begin with, there are two courts of concurrent jurisdiction, or rather having simultaneous jurisdiction, that is the Civil Judge Senior Division and the Civil Judge Junior Division, from whom appeal lies to the District Court, then the High Court and the Supreme Court. Each of these courts have an original jurisdiction to try civil disputes for different pecuniary amounts or for different territories. And to hear these matters, these courts will become civil courts when they're hearing the matter originally. For example, in our Bombay High Court, when a cause of action accrues within the territory of the city of Bombay, the municipal limits of Bombay, and there is subject matter jurisdiction, that is to say that it is a civil dispute not excluded by any statute. And lastly, that the claim is above ₹1 crore, then the High Court has original jurisdiction to hear the matter. High Court becomes a trial court, and therefore High Court is a civil court who can go through this journey, or before whom the whole journey of a civil suit will go through. Therefore, each of these courts, even the Supreme Court, can be a civil court in certain cases when it comes to matters under Article 124 of original jurisdiction of civil court, and they can try matters. And obviously, at the district level are the district courts, and below them are the Civil Judge Senior Division and the Civil Judge Junior Division. When it comes to metropolitan cities like Bombay, there is something as we know as the City Civil Court. So there are various types of civil courts which have original jurisdiction to hear disputes of a civil nature. And when they hear these disputes of a civil nature, they are originally as original courts, as of exercising original jurisdiction as trial courts, they become civil courts. And therefore, what is a civil court will be any court which originally hears a civil dispute. Once these concepts are clear, is when we can actually begin with the journey of a civil suit. Now, to begin with the journey of a civil suit, there are a few things which we need to understand. Is that what the Civil Procedure Code provides for under is the procedural law, and the entire procedure for the civil disputes is provided under CPC, which is also very interestingly provides for the substantive law. CPC is divided into two parts. One part is the general, the sections, which is the substantive law, and the other part is the procedural law, which provides the entire procedure under what we know as orders. So one is the sections and the other is the orders. What the procedural law basically does, as we all know, it's a very famous saying, is that procedural law is the handmaiden of justice, or rather, to seek justice, what we require is procedure. Substantive law just defines the law. These are basic concepts which I'm sure all of you are aware of. But why this is important is that when we begin the journey of a civil suit, we must approach it as if we're approaching a movie, or we're watching a movie, or rather reading a nice, interesting story. Because the journey of a civil suit is actually, it progresses like how a story progresses. It begins with a preface, a kind of interlude, prelude, goes on to the main crux of it, where the actual instances take place. And then thereafter, it moves to the end, where we have the final climax or the decision after the entire trial takes place. This journey begins like a story. I would ask a question to all of you firstly. The question I'd ask to you is that in case today a certain wrong takes place, what would you do? If you had to file a civil suit, what would you do? The first thing that you would be doing is to understand what are the reliefs or where you're injured. When we visit the doctor, we will first tell the doctor, where is it hurting you? Similarly, when you be visiting a lawyer, the first question that will come to you is, where is it hurting you? What is the wrong being caused? In example of a recovery claim, if tomorrow someone owes you money and you need to recover those monies, the first thing you must ask yourself is that, where am I hurt? Where is it hurting? And the answer is obvious, that you require to recover your money. The once you understand that you require to recover your money, you must first ascertain that what is the jurisdiction of the court, or which court will have jurisdiction. And that is why it becomes of utmost importance to be aware of what is jurisdiction. That is, where firstly, within which territory the cause of action is accrued. Secondly, what is the claim? What is a monetary claim? And therefore, which court will have pecuniary jurisdiction to claim this? And whether your recovery is barred under any law. Because your recovery from the civil court is barred under any law. For example, if you have to if the bank has to recover money, then that recovery claim will go before under the provision of SARFAESI, and therefore the civil court will not have jurisdiction. So once you understand that a civil wrong has taken place, or rather there is a civil dispute, the first thing you must ascertain, or the first stage of a civil suit, is ascertaining jurisdiction. Okay, that is territorial, pecuniary, and subject matter. And once you ascertain the jurisdiction, one must ascertain which court you have to approach. Once the jurisdiction is ascertained, once your reliefs are understood, once your cause of action is accrued, that is when you approach the civil court. And therefore, the question I would ask myself, or the question one must occur, is what will be the first step, or what will be the first stage of a civil suit? The first stage obviously will be that when you know that a wrong has occurred, you must firstly ascertain from where the wrong has occurred, or rather, who are the parties who will be parties to this dispute. And that is how the orders begin of the CPC. That is, order 1 begins with parties to the suit. So therefore, when we begin, like I said, it is like a story which progresses like a movie. That is why CPC also goes like a movie or like a script. And when we understand that a court has jurisdiction and a civil wrong has taken place, the first thing that will occur, the first question will occur to us is, who will be the parties to the suit? And that is when order 1 steps in, or the first scene of the movie takes place. That is, you determine who are the parties to a suit. The parties to the suit will obviously be firstly the plaintiff. Plaintiff is the person who's making the claim, again, who can seek reliefs. Okay. And the second, the opposite party, we call as defendants. The defendants under order 1, rule 3, have to be persons against whom a relief in respect of a particular transaction or series of transactions can be claimed, or rather, where against whom a cause of action is accrued, and to remedy that wrong, the person, you can claim certain reliefs. And that is what order 1 provides for. Order 1 is so expansive, and the whole idea behind order 1 is to make sure that the person who's claiming a remedy, his remedy should be exhausted within this, that he should be a necessary party to that suit, and he can bring in any party. Therefore, order 1, rule 10 also becomes very important, because when you decide who are the parties, there's also a power given under order 1, rule 10 to add or delete the necessary or the unnecessary parties. That is the necessity of order 1, rule 10. So like I said, the first thing would be to understand who are the parties, or against whom are you claiming certain reliefs. Once you understand that, the procedure under order 1 must be followed to the T, where you can add the necessary parties. The unnecessary parties cannot be added. and therefore whoever you're seeking reliefs against will be added as parties under Order 1. Order 1 is very interesting, in fact, because Order 1 does not only give an individual a right, but it gives not only one person, but various persons can file a suit together if they have a common cause. Therefore, plaintiffs also can be numerous, as defendants can be numerous. Plaintiffs also can be numerous. One plaintiff can file on behalf of himself as well as on behalf of various others as a representative or in a representative capacity, and that is known under Order 1, Rule 8. So, therefore, that is the whole gist or crux of Order 1. That is to begin with, who are the parties or the necessary parties to a suit. Similarly, once the first scene is over, or rather, once we determine who are the parties to your claim, the next question that will occur to you is what is to be done once you know the court, okay? You know that who the parties are, you know where it is hurting you. But then what is the next step to understand, to make this claim, or what is the second stage or the second stage of the journey of the civil suit? And that comes under Order 2, which speaks about frame of a suit. So what Order 1 deals with is parties to a suit. What Order 2 will deal with is frame of the suit. So when it comes to frame of the suit, one must understand is that when you are claiming something or when you're going to court to claim something, you have to be fair to the court. The plaintiff has to come with clean hands. He must come with honest intentions and with complete bona fides to the court. And therefore his claim, which he claims, should be his entire claim. I'll give you an example. Today, if I have a property and there's an illegal or there's a trespasser, illegal occupant in that property, and I want to evict this person, and while evicting him, I also want to seek damages for the loss caused by him, I cannot be tricky with the court and go to the court only seeking eviction and then later on say I will claim damages later on. Okay. Or rather not claim damages and then come after getting eviction decree and come saying give me damages now. That is impermissible, because when you come to the court, you have to claim the entire relief, and that is what Order 2 provides. In fact, Order 2, Rule 2 is a very important and relevant provision for all of us to study, especially if you're practicing on the civil side. That is making sure that your claim contains the entire cause of action. If you omit any part of your claim, if you do not disclose the entire claim, then that omitted part or the non-disclosed part of your claim will be deemed to have been refused or will be deemed to have been ignored by you. And therefore, you will never be able to claim anything larger than what you have claimed when you first came to court. So therefore, your frame of the suit should be such, or the second stage of the suit, which is the frame of the suit, should be framed in such a way that your entire cause of action should be there and all the reliefs that you have claimed should be there within your plaint. That is what the second order, that is the second stage. Similarly, once you know the parties, once you know jurisdiction, once you know the frame of the suit, or rather the cause of action of the suit, and you claim all of that, the next thing is when you approach the court is how you approach the court. And therefore, Order 3 comes into play, and that is pleaders. Pleaders, advocates, agents. This, in fact, is something which will be of utmost relevance to all of us present today, because what this recognizes, what Order 3 recognizes, is all our rights. That is the right to be represented through an agent or an advocate or a pleader. So all of us advocates, when we represent our clients in a civil suit, we are actually representing them when the clients are exercising their rights under Order 3, under the procedure established under Order 3. Because what Order 3 basically determines is how a person will be represented in a civil suit by his agent or his pleader. In fact, service on a pleader or an agent is deemed to be service on that party itself under this order. And that is how wide and liberal it is in permitting a party to be represented in a civil suit. The idea behind this, obviously, is to come to the truth of the matter. So actual attendance of the party may or may not be necessary. A party appearing through an advocate who is duly instructed and skilled is enough to come to the truth of the matter, to remedy the claim of the person approaching the court, if it needs to be remedied, obviously. And therefore, the third stage is what we say is appointment of an agent or a pleader, that after we have determined the jurisdiction, determined the parties, determined the cause of action, the claim, you have to appoint an advocate through whom, or an agent through whom you can appear and be represented in the matter. This also recognizes how, or it also provides how a wakalatnama should be filed, what is the form of wakalatnama in a civil case, etc. Next comes is order 4. And order 4 also becomes the most important, because all of these things do not actually form a part of your claim. All of these things are just the exterior or the ancillary circumstances which support your claim, that is the parties, the advocates, the frame of suit. What order 4 provides for and becomes the most crucial stage is how the suit needs to be instituted. Or rather, once you have determined the parties, once you determine the frame, once you've appointed an advocate, okay, and once you determine the jurisdiction, you approach the court. How will you approach the court, or rather, how will you institute your suit? And the answer lies in under order 4, which says the suit must be instituted by presentation of a plaint. So therefore, after all of these stages are completed, the first actual stage of court would be when you institute the suit by presenting a plaint. So the plaintiff who seeks some sort of relief, who is claiming some sort of relief, he must approach the court by obviously presenting a plaint, which is provided under order 5. If you see, now I've completed a bit of it, and like I told you in the beginning, it is like a story or like a movie script. It is actually progressing. The stages of a civil suit are actually progressing like it is some sort of story. And it is very interesting that this Civil Procedure Code of 1908 had contemplated that this will be the procedure which will continue for time immemorial, and that is exactly how it is continued till date. And that is why it is in such a perfectly timed chronology that you don't need to change it. And whenever you are also going to start a civil suit or file a civil suit, you can actually go through the stages like how you go through the orders. That is where we stop at order 4. These 4 are basically pre-suit formalities, or other pre-filing formalities. Once you complete the stage of order 4, you are actually crossing the pre-filing formalities and you're actually entering into the suit formalities, or rather you're actually the claim formalities. So once the pre-claim formalities are complied with, you go into the claim formalities, which begin with order 5, and that is the next stage. Order 5, another very important provision to understand, to learn, to study as far as the practical aspect is concerned, because what order 5 provides for is service of summons. Naturally so, once you have the parties, once you have the court, once you have filed the suit, once you have presented the plaint under as per the procedure established under order 4, the next thing would be to issue notice. Issuance of notice is basically service of summons. Under a civil suit, there is no notice issued per se, but a summons is issued by the court or under the seal of the court to be served upon the defendant. And once this is served, that is when the defendant gets notice of the proceedings, so he can appear and be represented in these proceedings. And that is how order 5 begins with. So order 5 is basically service of summons. Notice, detailed provisions are given of how notice would be given. And not only that, but the provisions given of when the person should appear. As everyone must be aware that once summons is served, a defendant or the party receiving the summons has 30 days to appear before the civil court who has called upon him and file his written statement within those 30 days. And at the most, that can be extended for a period beyond 30 days to a maximum of 90 days. So total of 30 plus 9 days, that is 120 days, is the period given to answer the claim of the plaintiff, to answer the summons issued by the court, and to appear. Very interestingly, order 5 also is quite a fairly large order. It has got about 20 to 25, 22 rules. And not only do they provide how notice needs to be served or what needs to be provided under notice, but it also provides whom a notice can be served to. So not only the party to whom the notice can be served or other summons can be served, it can be served, it has to be served to the court through its bailiff or by the party, the plaintiff himself. But it can be served not only on the defendant or the party to whom it is served, it can be served on the family member in case there's an adult member of the family residing there. So a family member can accept service. An agent can accept service. So if there's an authorized agent of a person, then he can accept service. And that is what Order 5 provides. What kind of agents can actually accept service of a party? And therefore, accordingly, Order 5 will thereafter also provide in case service is refused, because if someone wants to be crooked, if someone has malefides, he may not accept service. But what Order 5 also provides is refusal for service. If it is done, then what is the next step for ensuring that service is refused, to ensure that the service is given? Because basically what Order 5 recognizes or gives importance to is audi alteram partem. The basic principle of natural justice recognized under the constitution of our country has been followed for time immemorial. And therefore, what Order 5 does is that it recognizes audi alteram partem, or the concept of audi alteram partem, and puts it into force by giving detailed provisions of how both the parties will be ensured to be heard. In case the party still does not appear, then obviously audi alteram partem will not apply. But to ensure that each party gets an equal opportunity of being heard, Order 5 gives detailed provisions to ensure that all the parties have been given a chance to appear. And if they fail to appear, they will obviously face the consequences. And therefore, in case a party refuses to appear, then Order 5 Rule 20 comes into play, which talks about substituted service. So if the party is not receiving service through physical or through hand delivery or through post, then there can be a pasting order. The court can order for the notice to be pasted on the property or outside the house of the defendant, or even in the courthouse, or even by paper publication. And even the bailiff who does this can be examined by the court to verify whether the party has actually been served or not. In fact, the bailiff's report is actually an affidavit, which amounts an affidavit. The bailiff must state it on oath, and the bailiff can be examined and cross-examined by the parties to verify whether parties have been served or not. And therefore, a detailed chapter, a detailed order has been given of how service is to be effected and how this stage of the civil suit needs to be complied to the T. Once service is done, what CPC provides, or the next step, is known as Order 6. Under Order 6 is known as pleadings. Pleadings compile of order. The pleadings compile of plaint and written statement. What the pleading includes is basically the plaint, which is the claim, okay, where the suit is instituted, and the written statement. So how the plaint and written statement must be filed and presented, and what should be the contents of the plaint and the written statement is provided under Order 6. The drafting, or how one must draft, one must study in detail Order 6. To be a good draftsman, you must know Order 6 by heart, because Order 6 in detail provides what should be included in pleadings, what should be included in a plaint, what should be included in a written statement. Even simple things or even detailed provisions, like for example, under Order 6 Rule 2, there is specific provisions of how material facts must be stated. So if there are any facts which are material to a particular case, that must be provided under order in the plaint or in the written statement. And if that is not provided, those facts will never be taken into account. So how to draft a plaint, how to draft a written statement is provided under Order 6. Similarly, under Order 6, in case there are certain allegations of fraud, or if there are certain allegations of misrepresentation, then there are provisions under Order 6 of how fraud must be pleaded, of how misrepresentation must be pleaded. If there are facts regarding a certain contract, or there's a denial of a contract, then how one must deny a contract. That is all provided under Order 6. So the next stage of the suit will be to your plaint or your pleadings, okay, should be as per Order 6. In case your pleadings are vexatious, in case they're frivolous, in case they're embarrassing the court, in case they're scandalous pleadings, then the court can in fact even strike off your pleadings. Under Order 6 Rule 16, the court has the power to strike off pleadings, even if pleadings are against general public policy. Then also those pleadings can be struck off, and they'll have to be deleted, because no pleading can actually should delay the trial or embarrass the court. And therefore, that is the idea behind Order 6, to provide a expansive provision of how pleadings must be presented. And accordingly, that is the provision. Order 6 Rule 17 also something of grave importance, because in the end, everyone must be given a fair opportunity to be heard. So if there is some amendment or if there are some subsequent events which take place, then Order 6 Rule 17 provides of how pleadings can actually be amended and how there can be additional pleadings added. And that is what Order 6 Rule 17 provides for. Thereafter, a dual orders, that's Order 7 and Order 8. Again, these are still pre-trial formalities. These are not trial formalities. We haven't actually reached the stage of the trial. And we have generally all of these formalities or all of these procedures are complied with pre-filing, because you're not gonna draft the plaint, present it, and then make it as per Order 6. You're gonna do this all pre-filing. So therefore, when one gets a civil case or when one is going to commence the stages of a civil suit, Order 1 to Order 8 must be known by heart, or these stages of a civil suit or these procedures of a civil suit or part of the journey of the civil suit must be known by heart by an excellent advocate or by a budding advocate, because once these are known, one can actually proceed and one can make sure that his pleadings are complying with these provisions, and therefore we can actually proceed with the trial or come to the truth of the matter. Many a times people are not aware of these provisions itself, and they directly want to jump to the trial of the case without actually understanding how pleadings are to be drafted, without understanding how parties are to be made parties, and therefore the suits fail and the parties fail in making claims in the civil court even before the matter goes to trial, because none of these procedures are complied with. Therefore, Order 7 and Order 8 also become of utmost importance. Order 7 determines of how a plaint should be, what are the necessary ingredients of a plaint, which basically include the details of the parties, the details of the claim, the details of the court, the details of the relief. In case it's an immovable property, then you should give out the details of the property. And if none of these things are complied with, then the plaint can be rejected or the plaint can be returned. So it is of utmost importance that Order 7 is also studied thoroughly when you're drafting a plaint, because no plaint can be presented without these details. Similarly, when it comes to a written statement, which is provided under Order 8, Order 8 also gives a time period within which, as we know under Order 5 is already given, which is 30 plus 90 days to file the written statement. But Order 8 also provides of how denials are to be made. Order 8 disallows evasive denials. What is an evasive denial? For example, if I say A gave B 10,000, if A says that B owes me 10,000 rupees, B cannot merely say, I don't owe A to 10,000 rupees, but B has to say that I do not owe a single part of the 10,000 rupees or the entire amount of 10,000 rupees. An evasive denial would be B denies he owes any money. Now that becomes very clear because of the word any. The word any has to be used so specifically that therefore the denial cannot become an evasive denial. That is the idea behind Order 8, and that is the idea behind preventing what we know as evasive denials. Every pleading, every sentence, every allegation in the plaint must be denied. If it is not denied expressly or impliedly, then it is deemed to be admitted. Therefore, when you're drafting a written statement, one must always ensure that every allegation made against a defendant in the plaint must be denied. If that is denied, if that is not denied, then that will be deemed to be admitted. And therefore, this stage of drafting of a written statement must be in conformity of Order 8. That is the stage. Once all of this is completed, and once the plaint and pleadings are either there are no evasive denials or the plaint is complied with, one must also ensure that the plaint is not barred by law. And that is where another very interesting provision of Order 7, Rule 11 comes in. In fact, various matters are dismissed on the basis of Order 7, Rule 11, where the plaint is rejected because it might be barred under any statute, or because there's a misjoinder of cause of action, or there is deficiency in payment of court fees. And these objections, the court will look through only by reading the plaint. So if upon the bare reading of the plaint, it is observed that the plaint is liable to be rejected, then that plaint will be forthwith rejected by the court, and there will be no going back, because then your claim is dismissed. And therefore, like I said earlier, that compliance with these orders is of the most importance to actually get the relief. not how you conduct the trial. And therefore, these stages of the civil suit are equally important, which one must give importance to. Thereafter, once all of this is done, like we're progressing in our story, in our movie, as our script is progressing, one must understand that once all of the pleadings are filed, everything is done. The next stage is a trial. A trial is a very long drawn process where the truth needs to be ascertained. The whole concept or the whole idea behind a trial is to come to the truth of the matter, to determine who is speaking the truth and who is not. And therefore, when the trial is going to commence, there's going to be an expansive analysis, studying of evidence and of the documents and of the facts of the case. And to avoid that, or to rather to shorten that, or to prevent any dilatory tactics or delay in getting reliefs, the CPC provides for various stages which are known as pre-trial formalities. Unfortunately, in my experience, I can stand corrected, but unfortunately, in my experience, these provisions are rarely used actually. And I would urge all of you to actually use these provisions, which I'm going to be narrating, I'm going to be explaining now that these stages, because when it comes to these pre-trial formalities, the courts abroad, the courts, Western courts, you can talk about courts in America or the UK, where the trial duration is much lesser than in India. It's cut short because they comply with these, or they use these tools given under CPC, where there are something called interrogatories, discovery, production. None of these are followed to the T before our civil courts. I will explain what they are. So when we speak about Order 8, that is still the drafting part of it, where we understand the stage of the written statement. Once all of that is done, comes Order 9. Order 9 is also very important because Order 9 is a obligation cast on both the parties. That's the next stage, which is known as appearance of parties. Failure of either party to appear will result in adverse orders or an adverse effect on that party who is not appearing. For example, if the plaintiff fails to appear on the date of hearing, or the plaintiff fails to get the summons issued, okay, then the plaint will be dismissed, the suit will be dismissed, and the claim will be rejected. Similarly, if on the date given for appearance the defendant does not appear, then the court can decree the suit of the plaintiff, because there'll be a presumption that the defendant has no defense and the suit will proceed ex parte. So when a suit proceeds ex parte against any party, that happens by under the provisions of Order 9. Order 9 basically provides for appearance of parties, of how the parties will have to appear. This stage becomes of utmost importance because this is when the parties get the first chance to apprise the court, to show the court the bona fides or the depth or the strength of the case. And therefore, from Order 9, we jump to the next order, which is Order 10, which also is of importance and very related to Order 9, is basically what the court speaks about is examination. Once the parties appear, what the responsibility of the court is to examine the claim of both the parties, to weigh or to balance the claims, and to see whether some sort of conclusion can be arrived at this stage only. So instead of going to trial under Order 10, if the court feels that there is some truth or there is some depth in the claim of the plaintiff and the defendant has no defense at all, then he may allow the plaintiff, he may decree the suit at that stage, that is pre-trial stage as well. Rarely do we know this, or rarely does this happen, because everyone has a chance to a fair and free trial. But there is a provision that once the parties appear, the court will have the opportunity to verify the claim of the under Order 10 and can actually at this stage itself decree the suit if the defendant has not presented any defense or has no valid defense at all. And therefore, decree need not only happen post-trial. Decree can happen pre-trial under Order 10 as well. There are also situations, because of the promotion of ADR in our country, there's also a provision where the court can refer the matters to arbitration, to mediation, in case the matter can be settled or in case the matter can be resolved through arbitration. So upon examination of the claim and examination of the documents, the court can even refer the parties to arbitration in fact, or through the Lok Adalat, instead of trying it before the civil court and overburdening the civil court or embarrassing the civil court. That is the situation, and that is what Order 10 provides for. Thereafter are the four most unused. I say, I don't want to harp on it too much, calling it most unused. That won't be proper on my part. But I am still saying it because, in my experience, the most unused provisions are these provisions. That is discovery, inspection, interrogation. That is under Order 10. There's production under Order 13. There's admissions under Order 12. And these three, that's Order 11, 12, and 13, if complied with, can save so much time of the court, can save so much judicial time, because in actuality, these stages have been provided for the benefit of the parties. What Order 11 gives is that the court, I don't know how many of you are aware, or how many of you have actually gone through this, is that a party may seek interrogatories against the other opposite party. What are interrogatories? Interrogatories are basic questions or inquisitions or acquisitions from the other party regarding the facts of the case relevant to the matter. For example, if there is a claim of trespass and the claim is that the defendant has entered into the plaintiff's property, illegally entered on the plaintiff's property on a particular date, then the plaintiff may issue interrogatories, okay, with the leave of the court, obviously, to the defendant. For example, in this case, did the defendant trespass into the property on so and so date? Although my example is very direct and the answer will obviously be of a bare denial, it is the crafty draftsmanship, or rather the smart draftsmanship, which can get out admissions at the stage of interrogatories, which will assist the plaintiff at the stage of trial. And therefore, this stage of interrogatories and discovery becomes very important. So every party has the right to seek interrogatories against the opposite party with the leave of the court under Order 11. Not only it's this, but they can also seek discovery. So you can even seek discovery of documents. You can ask a party to produce certain documents, to give inspection of certain documents under Order 11. Order 11 basically gives the power of a court, gives the power to a party to give a notice to produce certain documents, which that party will be relying upon during its arguments or in its pleadings. And those documents will have to be produced by that party on oath, on an affidavit. And then those documents can, if the party fails to produce, for example, if the plaintiff asks the defendant to produce certain documents which are known to be in the possession and custody of that defendant, and a defendant refuses to produce those documents in spite of notice, then the defendant will be disallowed from producing these documents later on. So therefore, this is a very crucial stage of the civil suit where one has the power to call upon the defendant or the plaintiff, or basically the opposite party, to give interrogatories and to give inspection documents along with copies of documents. This helps the plaintiff develop its case, or the defendant also. This helps the party develop its case, prepare its case, and get a stronger case for trial. That is the idea behind Order 11. Similarly, is Order 12. Under Order 12, there's a power given to the power given to parties to give notice to get admissions. For example, if a certain party has admitted a certain fact in its pleadings, then a notice under Order 12, Rule 2, to admit those facts can be given. And if the party admits those facts, then and on the basis of those facts, the party can actually seek a decree. I'll give you an example, a personal example of my case. I had filed a suit against my tenant. I was for the landlord. I, being an advocate, was representing a landlord who had filed a suit for eviction against his tenant, where the ground for eviction was that they had various grounds over there. One of them being that they had not paid their rent for a period of 10 years. In their written statement, the defendant admitted, or rather, defendant stated that they had not paid the rent for 10 years. However, they had paid on the 11th year and they're ready to pay the remaining rent also. This amounted to an admission that they hadn't paid for 10 years, which is a breach of the terms of the lease. Because of this admission, I gave a notice to admit facts to the tenant's advocate. They could not deny it because they had already admitted it in their pleading. And on that basis, I received a decree without actually going through a trial. Actually a full small causes trial was avoided, which generally takes about 10 to 20 years. That was avoided just by using a simple tool given under Order 12 or at this stage, which is known as the admission stage. So therefore, and decree can be obtained pre-trial under Order 10 stage as well as Order 12 stage. Order 10 stage is when the court examines the pleadings and realizes that the defendant has no defense. Under Order 12, when one of the parties admits or gives an admission to a certain fact which will entitle the other party to a decree. In these two situations, pre-trial, at the pre-trial stage, there can be a decree. And therefore, under Order 12, admissions or there can be a notice to admit facts which can be used to the advantage of the party. Another pre-trial formality or a tool given which must be used is Order 13. Order 13 talks about production of documents. At this stage, it is what it provides is that pre-framing of issues. It is of utmost importance for all the parties to produce originals of all the documents. Originals of all the documents must be produced on oath. These documents have to be admitted or denied. If the documents are admitted, they can never be denied thereafter. And once they're admitted in our practice, they are marked as exhibit. This becomes very important because once a document is admitted, then that becomes the final proof, that becomes the primary evidence of a certain fact. And that, as per Evidence Act, everyone is aware of what will be the consequence thereof. Similarly, if someone denies it, then the way of proving that document during the trial will be different. After that comes Order 14. Order 14, the next stage, a very important stage, a most crucial, and actually Order 14 is not the responsibility of the parties, but it is the responsibility set on the court to frame issues. Issues, as we all know, are facts, okay, or circumstances which are alleged by one party and denied by the other party. Any issue in fact or issue of law can be framed under Order 14 Rule 1. There are sometimes preliminary issues which are relating to law only. There's sometimes factual issues which relate to only the facts. On the basis of the issues, the plaintiff will prove his case and the defendant will prove his case. The burden of proof shifts through the issues. When the plaintiff has to prove something, the issue will read as whether the plaintiff proves so and so, so and so, so and so. And that becomes a crucial stage of issues that is under Order 14. After this, after framing of issues, we are done with the first half of a civil suit. That is all is the pre-trial part. Once issues are framed, trial commences, and the second half of a civil suit begins, or the last stage of the suit begins. It begins with Order 15, which talks about the disposal of the suit. What Order 15 speaks is that if there are no issues, Order 14 frames issues. Order 15 says if there are no issues between the parties, then the court may decree the suit. Again, without a trial, the court may decree the suit under Order 15 as well. So there's Order 10, there's Order 12, and now there's Order 15 also. So there are no issues between the parties. If there are no facts alleged by one party and denied by the other, then the suit can be decreed just for the asking without there being a trial. Thereafter comes Order 16, which is attendance of witnesses. This is when the trial actually begins, is because what Order 16 provides for is that it gives the procedure of how a witness will be produced before the court. In case a witness does not appear by the summons, then a warrant will be issued. His property can be attached. Therefore, it is of utmost importance for every person to answer the summons issued by the court. The court must issue a summons if it is necessary, if the fact needs to be proved through a witness. And therefore, Order 16 provides of how summons will be issued to a witness, how the witness will have to attend, and if he fails to attend, what will be the consequences. Next comes Order 17. Order 17 is actually not the next step. Order 17 is something of importance. But the reason, according to me, it is provided after Order 16 is because it is to avoid delaying a trial. Order 17 provides for adjournments. Order 17 says that not more than 3 adjournments can be granted. That does not happen factually or practically in our courts. The situation is much different. But as per the law, officially only 3 adjournments can be granted. More than that, then that party will not be allowed to appear. He will be struck off and he will lose. However, that is not what happens practically. What happens thereafter, or what after order 16, that is attendance of witness, order 18 becomes important because that is examination of parties. Examination of parties is basically the actual evidence stage. Examination of parties, in my opinion, is just a conformity or confirmation of Indian Evidence Act. It provides of which party will start evidence, will lead evidence, who will lead evidence first. Order 18, Rule 4 is very important and very peculiar because what Order 18, Rule 4 permits is leading of evidence through an affidavit. Under criminal trials, there's no affidavit of evidence, examination chief. However, in a civil case, affidavit of in lieu of examination chief is permissible, and that is the only way examination in chief is generally permitted unless the court desires to actually personally examine the party in person in the box. Otherwise, every party must file evidence through an affidavit at this stage. On the basis of this affidavit, the opposite party will have the right to cross-examine that witness, and therefore the truth will be ascertained through this process, through leading evidence in conformity with the Indian Evidence Act. Section 137 of the Indian Evidence Act provides of how evidence will be led, how there should be examination, there should be cross-examination, re-examination. All of this is in compliance or is in consonance with the procedure established under Order 18, which provides for the examination of parties. And that is the stage. So therefore, after issues are framed, witnesses are called for. First, a list of witnesses is given under Order 16, Rule 1. Who are the witnesses? Once the list of witnesses given, thereafter there is examination of parties. Okay, under Order 18, and how the parties will be examined, the truth will be come out. Similarly, if some party wants to lead evidence, they must file an affidavit. That is provided under Order 19, and that is a stage where a party states on oath any certain facts which it can affirm under Order 19. The form of an affidavit is given under Order 19, and on the basis of this affidavit, the opposite party or the aggrieved party can cross-examine this deponent under the affidavit. Once examination is complete, the formalities of Order 18 are complete, the trial is complete. The next stage is the most important stage, or the most important stage for the parties, crucial stage of parties, which is Order 20, which we know as judgment and decree, which comes to the end or the last stage of a civil suit. That is Order 20. Order 20 is very basic. It provides for how a judgment and decree should be provided. There should be reasons. It should be pronounced in open court. It should be given maximum. It should be pronounced 30 days after the arguments are over. So once arguments are complete, the court has to pronounce a judgment in open court. That will be the final determination of the dispute. When we speak about decree, it becomes very important to understand the difference between judgment, decree, and order. One often finds that people don't know the difference between an order and a decree, and therefore it becomes of utmost importance, because what the court does at the end of the trial is not pass an order. An order can be interlocutory. It may not finally determine the rights. But after the trial is over, the only thing the court can do is pass a decree, that is, it can finally adjudicate and determine conclusively the rights of the parties in respect of a certain matter. And that is when the decree is passed. Judgment is obviously the reasons for passing that decree. The reasons of the judgment, the final order or the final direction or the final decision is the decree. And this is provided under Order 20. At the end of this is when you have something on paper. At the end of this entire exercise of churning out the truth of so much hard work, is do we come to the conclusion of what is the truth, or of what has actually happened, and who deserves a remedy against what wrong. That is how it is done. At the end of this is not the end of the CPC. That is only a part of the end of the CPC. Comes next is another entire stage, which is a code in its own. That itself can be a separate code, which is Order 21, which is execution. Execution, as we all know, is how the decree will actually be executed. There are various provisions for execution. The court has the power to seize property, attach property, sell property, auction property. It has powers to evict, forcibly dispossess somebody. It has powers to forcibly dispossess third persons. It has powers to even arrest persons. And that is the stage of the suit post the decree, and that is for execution. On a lighter note, one often says that after the decree, the actual matter between the parties begin, because in execution become like a second matter itself. It is not a it is not like it is the end of the road once the decree is passed. Many a times execution proceedings last for 20 years and plaintiffs still don't get the reliefs or defendants still don't get their reliefs. One thing which I missed out on, which you all must note, is under Order 8, when the defendant files his written statement, he is also entitled to file a written counter claim or a set off. We all know what the difference between a set off and a counter claim is. That when a set off is when a defendant has a certain claim against a plaintiff, then he can set that off through a set off. But if the defendant has a certain additional claim against the plaintiff, then he can claim that under a counter claim. And a counter claim becomes like a separate suit in itself and a separate plaint in itself. That is actually the end of a civil claim. That is actually the end of a civil suit. These are the main stages. Then the question that one would arise is that what happens in the rest of the orders? What happens from Order 22 to Order 51? There is almost 29 orders. What is there in these orders? Or rather, why are these orders there? The answer to that is very simple. After execution is provided for under Order 21, from Order 22 to about Order 26, there are miscellaneous provisions which help the court in deciding the suit. For example, in Order 22, what is provided is the effect of death, marriage of any parties. So if any party dies during the pendency of a suit, what will be the effect? If the right to sue survives, then the claim will continue. The heirs will be added as parties. This will be pending in a suit. This will be a stage only in a special circumstance if a person dies, or if the right to sue does not survive, then the suit will abate, the claim will abate. Similarly, Order 23 provides that if there's a settlement, if there's a compromise pending the suit, and then at that stage, for the compromise, what is the procedure, how the compromise will take effect. Order 24 provides for costs. If there's a monetary claim, then how the defendant will deposit the amounts. Order 25 provides for security. If the plaintiff is claiming certain amounts, the court may ask him to give a security for withdrawing certain amounts. And Order 26, also very important, known as commissions. So in case there are certain special subjects which the court does not have knowledge, or there's a situation for which the court cannot personally remain present to or before, then the court may appoint a commission to represent the court or be the court in that situation. For example, if there's a dispute as to the boundary of an immovable property during the pendency of the suit, it is not being able to determine where the boundary of the immovable property is, whether it is on this part or on that part of a fence, for example, then a court may appoint a third party independent commissioner or a commission, and that commission will go and file a report to see where the exact boundary is located. And that is the purpose of a commission. Similarly, from Order 27 to Order 37 are all different or special types of suits, or the procedure for these special suits. For example, Order 27 talks about procedure when there's a suit by or against the government. Order 28 provides for against procedure, or I think Order 28 is regarding indigent persons. I could be mistaken, or can correct me if I'm wrong. Similarly, there are various other provisions which provide for the summary suits under Order 37, interpleader suits under Order 35. So all special types of suits are provided from Order 27 to Order 37. These don't generally form part of the stages of a suit. They will only form part of a stage of a suit if that special suit is going to be invoked. So the actual stages of the journey of a civil suit will end at Order 21. Similarly, Order 38 to Order 40, those are of utmost importance from a practical aspect, because they deal with attachment before judgment, arrest before judgment, injunction, and appointment of court receiver. These four powers are given to the civil court under Order 38 to Order 40. These four powers given to the court are only at the interim or interlocutory stage. They are not for the final relief. They can be done only at the interim stage if the property of the plaintiff is likely to be wasted, or the suit property is likely to be wasted or damaged, or certain harm is likely to be caused pending the suit, which is irreparable. Okay, only in that case do these orders get invoked. Otherwise, there's no question of invoking Order 38 to Order 40. It is only to protect the interest or the property of the parties pending the suit. That is the idea behind it. That does not end the story, or that does not end the journey of the suit, because obviously every person is bound to make a mistake. To err is to human, and therefore to err is to human. Therefore, even the judges, the civil courts being presided by the learned judges can make errors, and therefore certain remedies are given in case errors are made by these courts. And these stages are post-decree stages. They could be said to be pre-execution stages, because execution is when the decree attains finality and it ends the matter. Pre-execution, post-decree, in certain situations, there are something which is known as appeals. Appeals are of two types mainly, or the general appeals are of two types mainly under the CPC. One is the first appeal, appeals from decrees under Order 41, and appeals from appellate decrees under Order 42, what we know as second appeal. So first appeal and second appeal. So there are two general appeals provided under CPC. So for example, if I just share the screen again. So if, for example, there's a judgment passed by the civil judge, senior division, okay, the person can file an appeal, first appeal to the district court, and only thereafter, if there's a substantial question of law involved, then can you file a second appeal to the High Court. That is the only time you can file a second appeal. Second appeal will only lie to the High Court in case there's a substantial question of law involved. Similarly, the judgment passed by CJJD, that is Civil Judge Junior Division, there'll be a first appeal to District Court, and thereafter a second appeal to the Bombay High Court in case of Maharashtra. And thereafter, there's one more SLP appeal to the Supreme Court, which we all know of. But as per CPC, in strict conformity under the civil law, appeals are of two kinds. There is first appeal and there is second appeal. Similarly, there's Order 43, which provides appeals from orders in certain situations. Since appeal is a creature of statute, in certain situations, certain orders only, for example, injunction order, a receiver order, those can be challenged by filing an AO, which we say in common parlance known as appeal from order. Order 44 provides for appeals by indigent persons. Order 45 provides for appeals to Supreme Court when there are matters of public and general importance. So these are certain situations when appeals can be filed. Leaving aside these appeals, there are three more concepts which one must understand when we are trying to study the civil law. They are reference, review, and revision. References are provided under Order 46. A reference can be made when the validity of a statute is being questioned in a civil court, or is being brought into question, or the civil court doubts the validity of a statute or the interpretation of a statute in a certain way in the civil court. If the civil court doubts it, then they can make a reference to the High Court. So reference lies to the High Court only when there is a question of interpretation of a statute involved. Thereafter comes review. Review comes into question only when there's a grave mistake or error apparent on the face of the record. Under Order 47, this is provided. So only when there's a mistake or error apparent on the face of the record, then only that can be reviewed by the same court. So reference goes to High Court, review goes to same court, and then lastly comes revision. Revision also goes to High Court, but revision is only in certain exceptional cases when the civil court refuses to exercise jurisdiction when it had to, or exercises jurisdiction when it did not have to. So when a civil court exceeds its jurisdiction, then that order becomes revisable under Section 115 by filing a revision. And that are these are the few post-order or post-decree remedies available. As far as the decree is concerned, the only remedy available is first appeal, and thereafter second appeal. You cannot file an appeal from order, obviously a revision, reference. Review might file because there could be an error, but apart from that, you can't file anything else against a decree. And that is literally or ultimately the final stage of a civil dispute. So to put this journey of a civil suit in concise or to understand it better, this chart helps us understand. So first thing first, just to revise, is the accrual of a cause of action as a first stage of this journey of a civil suit. So first thing is the cause of action will accrue. Thereafter, there'll be a determination of the jurisdiction, like I said, whether which court will have pecuniary, which court will have territorial, and which court will have subject matter jurisdiction. That court will have the jurisdiction. Thereafter, there'll be identification of the parties under, like we said under order 1, the parties are identified against whom you're seeking relief. The frame of the suit is thereafter determined. And once the frame of the suit is determined, the advocate is appointed. Under order 5, the plaint is lodged. Sorry, under order 4, the plaint is lodged, and therefore lodging of the plaint. Once plaint is lodged, summons will be served under order 5. Okay, that is the next stage. After service of summons, the parties will appear. They will file their written statement, the counterclaim setter, that will be the defendant. Okay, when you talk about the plaint at this point over here, okay, when you talk about the plaint over here, that time you are actually talking about making sure it is in conformity with order 6 and 7. We're talking the written statement, it has to be in conformity with order 8. When the parties are appearing, they have to be in conformity with order 9. After that comes the next stage, which we know as a pre-trial formalities, which I said we must use as production, discovery, interrogatories, framing of issues. Thereafter, there's a trial where there's examination chief, cross-examination, etc. The final arguments take place, judgment and decree, which is provided under order 20, appeal, second appeal under order 41 and order 42, and thereafter execution. This is the basic journey of a civil suit. These are the different stages of a civil suit. The provisions of CPC just promote this entire journey, just protect this entire journey, protect the rights. And the entire idea behind providing these many orders is to ensure that there's a fair and free trial and everyone gets an equal opportunity of making sure the civil claim is protected. And that is the idea. And that is the journey. Thank you.
When can we file a rejoinder application under civil suit?
So a rejoinder is not a matter of right in a civil suit. For example, a rejoinder can only be filed in interim proceedings or interlocutory proceedings. There will be no rejoinder to a written statement. When you file a plaint, that is your claim, and the defendant will file his written statement. Thereafter, plaintiff cannot file a rejoinder. That is not a matter of right. However, if you file an application and the respondent or a defendant files a reply to the application, and there are certain allegations made which need to be dealt with, then with the liberty of the court, you can file a rejoinder to that reply of the defendant.
In RAE suit, whether plaintiff has to mandatorily issue 15 prior notice upon defendant before filing plaint? If yes, could you please share judgment name?
Basically, there is no mandate for issuing notice under order 15. If you're talking order 5, yes, you have to issue notice. As far as small causes court is concerned, RAE suits are filed in small causes court. CPC is made applicable under the Presidency Small Causes Courts Act, and therefore you'll have to issue notice, and you don't require a judgment. The provisions of the law are clear.
Akshay, the next query is, what is a probate and at what stage needs to be used?
Probate is a provision under the Indian Succession Act. That is for in regards of will. That has nothing to do with a civil suit. As far as probate is concerned, probate is to be granted in the presidency towns of Bombay, Calcutta, and Madras if the person who made the will has died in those 3 cities, or if he was residing there last, or if he's made the will or he's dealing with properties in those cities. So that is the only situation. So in these situations, you require a probate. Probate means just a certificate of the court saying that this is the last and final and authentic will of this deceased person. If the probate is contested by the other heirs, then that is converted into a suit. And that is when the CPC in a way applies. But in general, it is not a suit. It is a probate. It's a different thing.
The next query is how to calculate court fees in civil suits or in recovery of money suits. How to calculate court fees?
You have to go through the Maharashtra Court Fees Act. There's a schedule given. That is very clear. The schedule in Maharashtra Court Fees Act will tell you.
Akshay, the next query is what is the difference between jurisdiction of subject matter and special jurisdiction?
Special jurisdiction basically is the subject matter jurisdiction, meaning jurisdiction is divided into three parts mainly. That is territorial. That means if the court will have jurisdiction over a certain territory only. Then is pecuniary, as a court will have jurisdiction only in respect of a certain money, a claim amount. And thirdly, subject matter. That is the court will have jurisdiction only in respect of a certain subject matter. Then there's a special court established to deal with special matters. That time the court is set a special subject matter jurisdiction or special jurisdiction. That is what it is.
Can an amendment of plaint directly be filed after giving a written statement?
Yes, it can be filed. Amendment can be done for the asking anytime before the framing of issues. Once issues are framed, you cannot amend the pleadings. But pre-framing of issues, you can easily amend it.
In continuation to REA suit query, 15.2 notice under Maharashtra Rate Control Act.
No, if there will be judgments, you can do some research. Under 15 to the notice is compulsory. If you don't give that notice, then it is obviously not a proper suit. You have to comply with that provision. It's mandatory.
Could you clarify what exactly is caveat through an example? Caveat.
Okay. Caveat, actually, I wish actually the time frame was less. I wanted to deal with a few more aspects. Caveat is something which I wanted to deal with. It is provided under section 148A of the CPC. Caveat basically is when you approach the court, telling the court not to pass any orders against you without being heard. So, example, if you have an apprehension that somebody is likely to get an injunction against you in respect of your house, okay, to avoid an injunction being imposed upon you without there being a hearing to you, you can file a caveat in the court you expect him to go to. For example, in the Bombay High Court, you can say that let no order be passed against me in respect of my house at so and so address by so and so if he files a suit. And if he does that, if you file that caveat, then no order will be passed without you being heard. You will be heard before any order is passed.